of Karen Mosca. We are here today set for our final in this case. We are conducting this through Zoom under a finding of good cause and agreement of the party. We are live streaming, and Ms. Goodman is making the record. Okay, we'll take announcements first.
Melinda Powell for the department. In lieu of a final hearing today, St. Francis is requesting the court enter an order for transitional monitored return.
Savannah Kincaid, I represent Ms. Kabuo. We are in agreement with the monitored return, Your Honor.
Stacey Zavala on behalf of Karen. In theory, I'm in agreement to the monitored return and the dates that have been set out there. My only concern is that as of right now, those dates were dates that Dad was visiting. And so I want to make sure that Dad's time is protected and that it sounds like they potentially have a plan for when that will be. And it does not matter to me what times those visits or days are, but I want to make sure that that is accounted for in this plan.
Okay. Quick procedural question. I show we still have an unknown father pled in. Did we just miss that somewhere? Because I show Mr. Mahindo is adjudicated.
We would, whenever he was adjudicated, we would have dismissed him out. I can go back and look at orders, Judge, and find out when that occurred.
Okay, we'll look for that.
Yes, I'm sorry, Judge. It doesn't automatically dismiss unknown fathers when other fathers are adjudicated, so I'll look into it as well. I might have just missed it.
Okay, all right. I just want to make sure we had that loose end tied up. So one way or the other, it may have already been done. So, okay. All right, then. Mr. Mahindo is present as well today. So I guess, Ms. Powell, if you want to kind of outline what the arrangement looks like. I mean, I've got a copy of the plan, so I mean, we don't need to go into every detail of it, but has Mr. Mahindo been given a copy of this?
And Judge, if I could, the St. Francis permanency specialist today is Sylvia Garcia. If we can ask her, she's gonna, if we want to swear her in, and if you want me to ask questions, I can, or if we can just informally, I'm good either way.
Sure. Ms. Garcia, I swore you in earlier today, correct?
No, Judge, you have not.
Okay, sorry. You solemnly swear or affirm that the testimony you'll give today will be the truth?
Yes, I do.
Okay, great.
The hearing opens with something far more important than paperwork. Every lawyer is already aligned on the big objective, which tells you the courtroom is no longer fighting over whether reunification should happen. The real battle has shifted toward the conditions surrounding it.
Okay, Ms. Powell, I'll let you go ahead and ask some questions.
Okay, thank you, Judge. Ms. Garcia, would you please state your name?
Sylvia Garcia.
And are you the permanency specialist for this case?
Yes, I am.
Okay, and you are asking for a reunification, a monitored return with transition, is that correct?
Yes, that is.
Okay, and are you asking for that to the monitored return be to the mother?
Yes, we are.
Okay, have you had conversations with the father regarding that plan?
Yeah, so we've had conversations, but he has not been provided the plan so that he could actually see those physical dates.
Okay, was he aware of the fact that you were wanting to return the child to the mother?
Yes.
Has he expressed an opinion in regards to that?
Yes, he has.
What's that opinion?
He stated that he does believe that Karen should be placed back with the mother, which is Francine. The only thing that he is concerned about is being isolated from her, just because they've built a really good relationship and bond, and he wants to continue to be able to be there for her so that she feels supported by him.
Okay, and is it St. Francis' intention to set up regular visitation for the father?
Yes, it is.
And will that include some sort of overnight visitation?
Yes, it will.
Okay, now the reunification plan doesn't have that in regards to father, does it?
It does not, but we can revise it and include that in there.
Okay, and so what are you considering for a schedule for the father?
So right now he's being off on Sundays. So Sundays are his days off, and he prefers Sunday and overnight, for him to drop her back off on Mondays before he goes to work. I'm not sure if he could possibly do 2 days. It would just kind of really depend on his work schedule. Right now, he has stated so far that pick up Sunday and then drop off Monday before he goes to work would work best for him, and it would give them more time together.
Okay, and can you get that that reunification schedule amended today and sent so that that can be included?
Yes, we can.
Okay, and have you had conversations with the mother? Is that workable for her as well?
So we have not talked to her about that yet. I did tell her that she did have to comply with his visits, but we didn't speak into the details of those visits. But that would be something that I would update her about and let her know how that's going to happen.
Okay, does she work?
She does not.
Okay, so she should be home on Mondays when the child's returned, at least for the summer. Is that correct?
Yes.
Okay, and then would it be appropriate once we get into the family reunification to go to mediation to try to work out a schedule for the mother and the father?
Yes, it would.
Okay, and that's assuming that the monitored return goes well. Is that correct?
That is correct.
Okay, I pass the witness.
All right, Ms. Kincaid, do you have any questions?
No questions, Your Honor.
All right, and Ms. Zavala?
Your Honor, in light of the clarification questions about dad's access, I have no further questions.
Once testimony begins, the discussion quietly exposes where the department's planning still has gaps. The reunification proposal looks organized on paper, yet it isn't fully complete because the father's parenting schedule hasn't been built into it.
Okay, sorry, I'm looking at a message from Ms. Katie.
And Kim sent me a message also in regards to the procedural issue that you had discussed. Mr. Mahindo was adjudicated father in the temporary order, and unknown father was dismissed in the status order.
Okay, yeah, I see where I adjudicated him at the adversary hearing. Okay. All right. Okay, so we're all on the same page there. All right, Mr. Mahindo, do you have any questions about this?
No, ma'am.
All right. So you understand we're going to be working with you about your work schedule, and of course, when the child is in school, you would have to drop her off, at
Monday.
school.
Yes, ma'am.
Okay. All right. Okay. So sounds like we're moving forward, and hopefully this will all go smoothly, and then we can, kind of get a final full-blown order, in the works, assuming everything goes well with the monitored return. So, Ms. Zavala, are your concerns alleviated at this point?
Yes, it is very important for Karen to have that access with her dad, and so I just want to make sure that that is specifically addressed, and that seems to be now. I've got no issue with the schedule that's laid out for mom, as long as there is that time with dad.
There's no reason why the child shouldn't have telephone access to him at any time she wants, correct?
From my perspective, absolutely. I think that would be important.
Okay. Ms. Kincaid, I think it's important your client understand that the child can call her dad whenever she wants to call her dad, and he can call her. I assume at her age, she does not have a cell phone, but I may be making a huge assumption there.
Yes,
There
Your
may,
Honor, I can explain that.
there may be 8-year-olds that have cell phones. There probably are. So, okay. It's just as long as she understands that that's a back and forth between the two of them that should not be, interfered with or disrupted. All right, then. Ms. Powell, anything further from the department?
No, Your Honor, I'm looking to see when our last review order was. Our last review appears to have been in March. Or, well, okay, it looks like April maybe. If we could just have a review hearing today, Judge, just to remain in compliance. The next hearing's not set until October, and that wouldn't keep us in compliance. So if we can just have a real quick review hearing today and enter a review order, that would be great.
Sure, absolutely. Okay, Ms. Garcia, if you want to just give us a quick update on everybody.
Yes, so Karen has been doing very well in placement. She's getting along with everyone. They've gotten a couple new kids, and she's been able to adjust to those kids that have came in. She's being respectful. She's following the rules. There hasn't really been any concerns. She's kind of started having nightmares recently, and those nightmares kind of were a concern as far as the therapist discussed. She just had concerns that Karen was interpreting those differently as far as like seeing shadows while she's sleeping. And Karen, I spoke to Karen in regards to those nightmares, and basically all she stated was that she's watched videos while she's watching kids YouTube. She's watched videos that come up that kind of scare her, but she has talked to placement about those, and they have continued to monitor just to make sure that she's skipping through those videos, because even though it's on the kids YouTube, just random things do pop up on there, and they kind of honestly feel that's where she's getting scared from. It's just maybe from those videos. Also, there was another child placed there recently that kind of has.
The strongest moment here isn't about visitation, it's about communication. Once the discussion shifts toward unrestricted contact between the child and her father, the court quietly establishes an important principle. Healthy parent-child relationships cannot depend on another adult's personal feelings.
She talks about seeing invisible people and things of that nature. So they kind of feel that maybe that's where Karen is getting those nightmares and those stories. I mean, as far as placement we don't feel that it's a concerning issue, but the therapist is working through those with Karen just to make sure that they're not a continuous thing. Mom has, which is Francine Cabu, she has continued to work services, be compliant with St. Francis. She definitely is excited about this reunification plan. She has stated that she's going to cooperate with the department with any type of visitation that is set out for Karen and any type of appointments or anything that she has. Mr. Mohindo as well continues to participate in his parenting time with Karen, and Karen really enjoys that time. His time has changed to Sundays recently just because of his work schedule. So Francine has Saturdays with Karen, and Patrick has Sundays with Karen.
Okay. All right, anybody have any questions for Ms. Garcia?
No, Your Honor.
No, Your Honor.
Judges,
Okay, then, I will go ahead and order the transitional monitored return to the parents.
Judge, as a procedural issue, that will give us a new dismissal date of December 15th of 2026.
Okay, that's my very next question. December 15th.
Yes, Your Honor.
All right, new dismissal date, December 15th, 2026. I'll continue the department as temporary managing conservator, and I will continue the child's current placement as we work into the reunification plan. Find that parents are in compliance with their family plans of service, and there is no continuing danger to the child, so we will ramp it up with the reunification plan. And I'll see everybody back October 15th of 2026 at 9, if that's necessary. My hope is that we may be done by then.
And Your Honor, I would ask that there be an order that Karen continue with her therapy. I think that's the plan anyways. But I just want to make it clear that through this process and the updated visit times that she'll still be going to therapy.
Absolutely. So if you want that in the order, we'll add that in. The child will continue with the therapist.
And Judge, do you want to go ahead and do a mediation, order for mediation at this point in time?
Sure. I don't have a problem with it. Let's try to get it done, say, before maybe August. I'm thinking maybe before school starts would be a good target. So maybe around before August 15th.
Right now, according to the family reunification schedule, the plan is to place the child in the home by July 27th. And
Okay.
so do we want to shoot for maybe September 1st, Judge? And then that gives that has the child in the home for about a month or so before.
Okay. Yeah, that's fine.
And
Judge,
Judge, I'm sorry.
Sorry, this was referred to mediation back in October. Do you want me just to reappoint the same mediator?
Yeah.
Okay.
Yeah.
And Your Honor, if we can reach an agreed order without mediation ahead of time, are you okay with that? I don't know that we can do it, but if we could, that would be great.
Absolutely.
The judge officially approves the transitional monitored return. The order still contains important safeguards. That tells you reunification isn't viewed as the finish line. It's another stage that must prove itself through continued success.
Mr. Mahindo, you've never requested an attorney. If you can unmute for me. Okay, Mr. Mahindo, can you unmute for me?
Yes, ma'am.
Okay. I think it would be very, very beneficial for you to have an attorney help you through this kind of wind down process.
Yes, ma'am.
Are you willing to fill out that paperwork and get that to my office?
Yeah, I can.
I'm sorry.
To have you.
You were breaking up. I'm sorry. What did you say?
I can fill it out, the paperwork.
Okay, I'm gonna have St. Francis get that to you, and then you can give it back to them. They'll get it to me. I just think it would be very beneficial for you to have the advice of an attorney as you're, working through some agreements and final orders, okay?
Okay.
Okay. All right. Okay, then, we'll get that handled and we'll get someone appointed so that you guys will have an attorney that you can loop in on this. I think that would be beneficial. So, okay. All right.
Your Honor, I do have something to say.
Yes, ma'am.
Yeah, about the phone to my child is not. She's still young. She does not need the phone.
Right.
What I want to say is like, is if Patrick want to see Karen, he has to call my husband because he's the head of my house. So if he want to come to pick up Karen, he has to call my husband. He has to have my husband's phone.
Judge,
Does
we
he
can
have
work that out, whether it's by an agreed order or by a mediation. That's something we can work out, I think.
Okay. All right. I just want to be sure that he's got a way to contact her.
Yes, so he need to call my husband if he want to talk to Karen, whatever, anything he wants. He has to call my husband because if he doesn't do that, sometime Karen he'll lose that respect to his dad because my husband is his
Hey,
dad.
Francine, we can talk about that, whether it's by an agreed order, we can
Okay.
have that in an agreed order, or we can discuss that in a mediation. All the communication stuff can be settled in an order, okay?
Okay.
Okay. All right, then. I'll see everybody back October 15th, unless we've got everything worked out by then. So I appreciate y'all.
One overlooked moment says a lot about the judge's mindset. The father never requested an attorney, yet the court raises the issue independently. That isn't favoritism. It's recognition that complicated family litigation can overwhelm parents who lack legal guidance. An attorney doesn't just argue in court. A good attorney prevents costly mistakes before they happen. The judge is trying to reduce confusion before final custody orders are negotiated. That's forward thinking rather than reactive judging. Courts often function more efficiently when every party understands both their rights and their obligations. Better representation usually produces clearer agreements, fewer misunderstandings, and far less litigation after reunification has already begun. The mother's comments create the most revealing power dynamic of the hearing. Her focus immediately shifts toward requiring the father to communicate through her husband. That statement changes the conversation because it introduces another adult into an already delicate parenting relationship. Whether intentional or not, it raises questions about future boundaries and decision-making authority. The judge wisely refuses to settle that issue impulsively. Instead, the court redirects it toward mediation or a formal order where expectations can be clearly defined. That's an important distinction. Emotional family dynamics should not become courtroom policy without careful consideration. Clear legal boundaries always outperform informal family rules when long-term co-parenting is involved. The hearing closes with cautious optimism instead of celebration, and that's exactly the right tone. Everyone appears committed to moving forward, but the court avoids assuming success before the reunification process actually proves itself. That restraint reflects experience. Family court decisions are built on sustained behavior, not hopeful promises. The judge leaves multiple paths available, including negotiated agreements, mediation, continued services, and another review hearing if necessary. Those options reduce pressure while preserving accountability. The case ends with momentum, but not complacency. Every participant now understands that future cooperation, not courtroom arguments, will determine whether this child reaches permanent stability without needing to return to another contested hearing.